Good morning, everyone. And unlike usual press conferences, because I know that there is interest in this case beyond just Maricopa County in Arizona, there are a few preliminary remarks for anyone who may utilize this video for information or understanding about this case. So I'm Bill Montgomery. I'm the elected Maricopa County attorney. I'm in my third term of office and my 9th year of service. At the outset, I'm very mindful that what I say here today could potentially be used at some point in the future. Okay, I'm going to start over. Please keep your voices down so that everybody can get the audio. At the outset, I'm very mindful that what I say here today may be used at some point in the future to try and limit the ability of the state to hold the defendant accountable for his conduct. Accordingly, I will choose my words carefully and abide by Arizona's rules of professional responsibility, including Ethical Rule 3.6, which covers pretrial publicity, and Ethical Rule 3.8 that establishes the special responsibilities of a prosecutor. We will not jeopardize the due process rights of the accused as we seek justice for Elijah and his family. I also will not name the defendant here today. Our community has lost forever what Elijah would have contributed, and it is his memory, his name, that we should acknowledge and remember. Elijah Al-Amin did nothing to warrant the brutal and senseless attack that took his life in the early morning hours just 1 week ago. From everything we have learned about him since that attack, he was a fine young man and just the sort of youth we want living and learning in and contributing to our community. Again, Elijah did nothing to justify the taking of his life. Yesterday, Maricopa County grand jurors returned an indictment charging the defendant with 1 count of first-degree murder. The indictment is not evidence of guilt, and the defendant is presumed to be not guilty. We will still be required to prove each element of the crime charged beyond a reasonable doubt. The case has been assigned to our Capital Litigation Bureau. That bureau specializes in cases such as Elijah's. Under Arizona law, a conviction for this crime is punishable by either natural life in prison or death by lethal injection, as determined by a jury. Evidence of bias or hate in the commission of a crime in Arizona can result in a greater punishment for a defendant than for one who commits the same crime without evidencing hate towards a victim. Specifically, Arizona law provides that evidence that a defendant committed the crime out of malice toward a victim because of the victim's identity in a group or because of the defendant's perception of the victim's identity in a group listed in Arizona law, specifically where someone manifests evidence of prejudice based on race, color, religion, national origin, sexual orientation, gender, or disability, can be found to be a hate crime. Arizona law does not have a separate offense of hate crime. We as a state have chosen not to make bias an element of an offense that must then be proven beyond a reasonable doubt in order to convict a defendant in the first place. Instead, what Arizona has chosen to do is to allow us to charge someone with criminal conduct, have them found guilty of that, independent of bias, and then allow prosecutors to introduce that evidence to the trier of fact and have their sentence increased as a result of their motivation for committing the crime. And I'm going to say this again so that people understand. Arizona has chosen to keep it simple and straightforward for prosecutors to be able to convict someone of having committed a crime. And then we're able to use evidence of bias to enhance that sentence, to increase the penalty. So again, we start with the presumption that criminal conduct that we can prove someone committed is a crime. And then what matters for punishment is why they committed that crime, and if there is evidence of bias, to increase the punishment accordingly. I'm going to say it a different way too. I want people to understand. Arizona does not discount what may have motivated someone to have committed a crime against a fellow human being. Instead, we use that information not to make it more difficult to convict and have someone found guilty in the first instance, but rather to then be able to apply the appropriate sentence and punishment for that attitude towards someone who had been victimized. At this point, there is no evidence of any association between the defendant and any hate groups, white supremacist or otherwise, and we have seen no evidence of the adoption or proclamation by the defendant of white supremacist ideology. And let me be perfectly clear, hate has no place in our society. We all share the same nature as human beings. Therefore, we all have the same innate value and dignity. A violent crime against a fellow member of our community represents a crime against that person that impacts them, their family, and represents a violation of what we expect from one another living together in a civil society. The next steps in this case will involve a review of whether the state should file a notice of intent to seek the death penalty. We do this review for every first-degree murder case that is filed by the Maricopa County Attorney's Office to ensure consistency in how we review these cases and consistency in how we seek justice up to and including the death penalty. It is at this point that we will look at all available evidence, including any allegations of mental health issues and evidence of hate towards Elijah due to the categories I previously listed. If we reach the decision to not seek the death penalty because there is no reasonable likelihood a jury would return a verdict of death, or because we cannot overcome thresholds established by the U.S. Supreme Court to pursue the death penalty in the first place with respect to mental illness or intellectual disability, and it is way too soon to even reach tentative conclusions about either of those issues. I'm merely identifying matters we may have to address. If we choose not to pursue the death penalty, the case will still go forward as a first-degree murder case, with the natural life as the penalty that would be imposed following a conviction. The next hearing in the case will involve an arraignment, and then there will be an initial pretrial conference set. The state has 60 days by Arizona's Rules of Criminal Procedure to file a notice of intent to seek the death penalty. I expect us to have an agreement with the defense, as we do in so many other cases where there's a lot of information for us to review, to agree to extend that deadline to allow us to conduct a thorough review. We do not pursue the death penalty lightly, and we take every crime, such as the one before us, very seriously. What makes this offense so tragic is we had a 17-year-old who did absolutely nothing. As a father myself of a 16-year-old, I can't imagine what this young man's family is going through. And it is a significant loss to our community. What questions do you have? Yes, sir.
I just wanted to make clear that Arizona doesn't have a title of hate crime per se, but those types of factors can be weighed if convicted in sentencing. Is that correct?
That is correct. And the one thing I would just point out is that in this instance where we're dealing with a first-degree murder charge where, as I mentioned, the two sentences that can be imposed are the most serious that Arizona law provides for. That evidence may be important when it comes to communicating with the jury about the need for the sentence that we're seeking. But, I mean, in reality, there's not much to enhance per se. But that doesn't take away at all from how we might review that evidence and how it might be used in the prosecution.
And at this point, do you guys plan on seeking that enhanced penalty, or is that too early to tell?
It's way too early to tell. Acknowledging that, that I'm very aware of reporting to date, and I have reviewed the police report, so I know what was said within it. So I'm merely at this point identifying that is an issue that we will have to review. Yes.
Is the enhancement something prosecutors seek, or is it something the judge just decides?
It's an allegation that we have to file as the state, and we have filed it in the past. The most recent incident involved a criminal damage charge and trespassing at a Tempe mosque. And the way our statutes are set up then is even in that type of offense that involved the lowest class felony under Arizona law, we still could allege that it was bias motivated and seek a sentence enhancement there. So that's an important distinction to make. Arizona law doesn't require us to rely on a violent crime to allege that it may have been motivated by bias. We convict for the underlying criminal offense, and then if we have that evidence, we can seek an enhancement regardless of what that crime may have been.
I can't remember, was the enhancement accepted by the judge?
Well, in that particular instance, because of the defendant's prior criminal history, they were eligible for probation. So the enhancement wouldn't apply unless and until they were revoked on probation and sent to prison.
Oh, okay.
And to be clear
So-
here, what is the enhancement if you guys were able to pursue a race bias type charge to a first degree murder charge, or, you know?
Yeah, effectively, other than providing the full context of the underlying crime, there's not much more to go beyond if someone's being sentenced to natural life. And by the way, I didn't specify it in how I described that sentence, but back in 2012, the legislature changed our statute. So if you're an adult convicted of first-degree premeditated murder, the only two sentences that can be imposed is natural life without the possibility of parole or the death penalty.
And when it comes to the mental health side of things, this man, it looks like, who's right now being charged, was released, what, a day or so before? Department of Corrections says that he was, although he had some mental issues, was fine to be on the streets. How much does mental health play a role when it comes to potentially prosecuting this case as a first-degree murder case?
At this point, and getting back to what I said at the outset, not wanting to jeopardize any due process rights or inhibit the ability of the state to prosecute the case. I don't want to get any details on that. I will just simply say that that is an issue, obviously, that is something we will have to address in this process.
And how often are we seeing that where people are being released from prisons and, you know, sometimes they're not being classified as someone that needs to be watched out for and not having this type of medication and potentially committing crimes?
Well, and so to speak in general on that, and not related to this particular case, the designation of someone who may have a mental illness and requires treatment doesn't always occur within the criminal justice system because of the wide variety of mental illnesses that people can present with. And this is an area where we as a society have to get better at developing modes and methods of treatment and community-based treatment rather than relying on the criminal justice system to be the default provider. You asked the question, how many times may people be released from DOC with these circumstances? I don't know. And I don't think we as a criminal justice system here in Arizona necessarily have a way of capturing that data either. What we do within Maricopa County is to try to provide the lowest level of intervention possible, and that usually occurs within the jail system. But mental health issues are a complex factor that the greater they present, the more difficult it is for us within the criminal justice system to figure out the best resolution. And that's nothing new.
So there's no person.
Acknowledging those difficulties and seeing how people leave ADC, does it make you rethink how many people you send to prison?
Well, we've had a 30% reduction in who we send to prison over the last 7 years. So I don't think that question fits within the context of what we do on a day-to-day basis. The reality is that we seek to use prison for those where that's where we're at in trying to prevent further criminal conduct and safeguard the community. But my tools as a prosecutor are those that are provided by the legislature. I don't have the means on my own as a county attorney to designate someone as a mental health risk and then make sure that they go off somewhere for treatment. Our criminal justice system isn't set up that way.
But acknowledging that there are shortcomings with treatment for drug issues, like you just said, and the treatment for mental health issues, I'm just saying, like, does that make you rethink sending people to ADC at all? Maybe send them to other programs if you're saying, you know, that's not the place to send people with mental health issues.
Well, let's not conflate substance abuse with mental health necessarily. We can address them in a broader context of behavioral health. But before someone goes to prison in Arizona, they've had multiple opportunities, unless they've committed a dangerous offense, a certain sexual offense, or a dangerous crime against a child, or they're a drug trafficker or a drug seller, a significant one. Again, I would say that the question's a non sequitur. We don't have the means as prosecutors to say, and courts don't necessarily have the authority under the law to say, okay, this is a repetitive offender, but instead of sentencing them to 5 years in prison, we're going to sentence them to 10 years in the state hospital. Our system just isn't designed to be able to come up with those types of resolutions.
I have a question. Does the Arizona Department of Corrections have any responsibility for a prisoner after they release them? Is it up to the Department of Corrections to decide whether somebody should be, like, left on the street?
Well, in general, and I'm not the spokesman for the Department of Corrections, nor do I represent them, so I don't want to get too much into that. But I will say that where someone is sentenced to prison and they are going to be released and they are not, after their release, going to be placed on probation, then they will serve 1 of every 7 days they were sentenced to prison for on community supervision. And that is a program that is the responsibility of the state. When someone is placed on probation, typically after they're released, they're going to have to report to a probation officer at the county level. And that's the general scenario.
But what's community supervision? I mean, is that?
Community supervision, we don't have parole in Arizona. It's for lack of
In
a...
this case, if the corrections had any responsibility at all, or if once they're out, they're out.
No, there still is a responsibility for the person when they're released going back to the community to make contact with whoever is supervising them, whether it's under community supervision or it's with adult probation.
Did that happen in this case?
I don't know.
And along those same lines, do we know, was proper protocol followed in the release of the suspect in this case, as far as you know?
I have no idea. Again, the way our commitment process works is once someone has been convicted of an offense for which they can be sent to prison, either as a result of a jury conviction or as a result of a plea agreement, a county superior court judge will then issue a commitment order, and then that person is transferred from county custody to state custody. And what happens from that point is at the state level with their protocols and procedures. And as a county attorney, I'm at the county level, not disclaiming responsibility for what we do, but that's a point in our system then where the responsibility transfers to the state.
Now, this suspect has had multiple charges in the past, including somewhere, you know, he threw a brick at people, he was supposedly hearing voices, had mental health assessments. How could his past, his criminal past, impact what you guys do in the future when it comes to prosecuting this case?
I'm not aware of him actually throwing a rock or anything. What I'm aware of is that it may have been used to communicate a threat. All of that fits into the mix when we review this particular case and the type of punishment that we might be able to seek. How it's weighed, what that calculation is, too soon to share any conclusions, and I don't even want to get into a discussion about tentatives either.
And when you were talking about the mental health system, you say that our justice system isn't set up to send someone to a mental health hospital and, you know, for 10 years instead of sending them to prison for 5 years. Is there something that needs to be done or changed to maybe change and give prosecutors and judges more flexibility and how they handle these type of cases?
My initial response is we need to quit looking at the criminal justice system as the end-all and be-all to fix societal problems. We need more of a community-oriented approach where individuals have the opportunity to be diagnosed and treated within a community setting before we start using the punitive sanctions of the criminal justice system to try and force compliance. Mental health is such a complicated issue in the first place. I mean, if you pause and think about it, the more someone is self-aware that they are suffering from, to whatever degree, issues associated with mental illness, they're often the least likely to get treatment because they present as someone who is much more competent and aware. Someone who then is in most need of treatment and services and lacks that ability to objectively assess themselves and identify themselves for treatment are often ones where they're not presenting for diagnosis, they're not presenting for care. And there certainly is a lot of areas in that regard when we look at community-based treatment that the legislature can work on. And I do know in this most recent session, as an example, Representative Nancy Bartow began some stakeholder meetings to try to come up with alternative housing arrangements for those who suffer from mental illness. But I don't want to end on that point here. That's a separate conversation that is important that the community needs to take into account. But as I began my remarks, and this is such a difficult case too, as I'm sure you can appreciate, where again, Elijah did nothing wrong. He was at a Circle K, or he was at a convenience store. I don't want to ding the convenience store. He was just in there shopping, buying whatever a 17-year-old's going to buy. And again, as a father of a 16-year-old, I can't fathom trying to make sense for Elijah's family of just going to a convenience store and that's it. Your child is gone.
Why are you so emotionally attached to this case?
Oh, it's not necessarily just this particular case. In my role, I can't separate the fact that I'm also a father and I'm also a member of this community. And this hurts. You know, not my son. I don't walk in the shoes of his family. But this is my home. And to see something as senseless as this, it should bother all of us. And so to that degree, hey, I feel what I feel. I think it makes me good at my job. And our community is also blessed by having a number of men and women who work in this office who approach their jobs the same way. So, there's compassion, there's empathy, and when you face something like this, if it doesn't bother you, I think you need a gut check.
And being so emotionally attached to this case.
Well, I didn't say I was emotionally attached to this case. I said what I said, because I don't want that then to be used, that somehow we're treating this case differently and the defendant is being treated unfairly.
That's what was going to be my next question.
Okay.
Will you recuse yourself?
Oh, hell no.
Handle this case?
Oh, no, absolutely not. Again, rules of evidence, rules of criminal procedure, and how we handle cases are based on the evidence and the facts at hand. And if me or any other prosecutor in this office were motivated to make sure that justice was done because of the particular facts and circumstances, good.
What's your message to the family?
I'll share that with them in the future.
Can I ask a question?
Sure.
Could you comment on I guess it would be up to the family to file a civil suit at the federal level, but what can be done at the federal level in terms of hate crime or civil rights violations?
I don't see any role for the federal government in this. The Peoria Police Department is doing their job, and this office is doing its job. If anything, at the federal level, people can start having conversations where, again, we acknowledge our shared humanity and the innate value and dignity that everybody has, and focus on that and building communities and strengthening and protecting them. And that's all I'm going to say on that.
Did you say you're not emotionally attached to this case?
I said that that's not anything that is necessarily a factor in how we're addressing this. I acknowledged my empathy and how this impacts me as a human being and a father and as a county attorney.
I've never seen you become emotional like this before.
You haven't been in enough press conferences then. Uh,
thought earlier we talked about it July 15th.
Yeah, we can get that information to you.
All right.
I have a
Thanks.
question. So the conversation actually, a lot had in this specific case, has geared toward mental health. Do you think this case also highlights the issue of racial relations that has been going on in the country?
Well, you're in, as I tried to towards the end, I think that conversation about mental health can take place outside of the context of this particular case. I want to stay focused on what happened to Elijah. And as I mentioned in my remarks, or I know you came in late, I'm not sure you heard them, but we've got no evidence at this point that this individual is associated with any white supremacist group or any other group similar to that. And we haven't seen anything that suggests this individual has adopted white supremacist ideology or proclaimed anything like that. So I would say that this particular incident, at this point in time with what we know, is limited to this particular incident.
Thank you.
Okay, thank you.